November 5th, 2017 started as an average Sunday for the congregation of the First Baptist Church of Sutherland Springs, Texas, which is a small community located right outside of San Antonio. And it ended as the deadliest mass shooting at a place of worship in American history. 26 people were killed, 22 injured. The shooter, Devin Kelley, was a former United States Air Force service member with a criminal history. In the aftermath of the shooting, 52 victims came forward and sued the federal government for their role in enabling Kelley's ability to commit this mass atrocity. Because you see, in the days following the shooting, we learned that the Air Force failed to submit Kelley's criminal history to the FBI's national database that would have prevented him from buying a firearm. So the theory of the case is pretty simple. Had the Air Force submitted Kelley's information, he wouldn't have been able to use the firearms used in Sutherland Springs. And every single firearm used in Sutherland Springs was purchased over the counter, meaning he had to pass a background check to get it. But how can the Air Force be responsible for the acts of a crazy person? That's the first thing I thought of, and that's why this is such an interesting case from the legal perspective. So I sat down with Jamal Alsaffar, who was the lead lawyer for the victims of Sutherland Springs. Joe Holcomb et al. Versus the United States of America. Jamal, how did you get involved in this case?
Well, the short story is I got mad. I was in the car with my wife, who's also my law partner, and we were not far from Sutherland Springs because it's not far from Austin, just outside San Antonio. And Texas, unfortunately, has become the situs of the most mass shootings in the country. And this one hit particularly close to home. We found out very quickly that the Air Force had a great role of responsibility in letting this shooter loose. And from that moment, my wife and law partner said, hey, I think this might be a case against the federal government. We have to do something. Enough is enough.
How did you find that out without any sort of discovery?
Well, it was a tweet. The Air Force, Secretary of the Air Force, released on their Twitter page a comment that the Air Force let this guy slip through the cracks. He should have been reported to the FBI background check system. So that's where it started. And we started looking into it. And immediately after the shooting, a congressional hearing was held. Several principals within the Air Force and the military under oath testified to a lot of missteps. And that gave us the opening. That gave us the sort of the door open so we could find out more. And what we learned was shocking.
And what exactly was that?
In short, for over 30 years, the Air Force, and not just the Air Force, but the entire Department of Defense, the Army, the Navy, Air Force, had spent the last 30 years failing to report the most dangerous people, felons, people with domestic violence convictions, people with mental health instability. For 30 straight years, have been failing to report these folks to the FBI background check system. That's the system that stops people from getting guns.
Yeah, so on that note, the theory of the case, and we have our little case notes here, is the ultimate question was whether the government failed to exercise reasonable care in its undertaking to submit Kelley's criminal history to the FBI, and Kelley was the shooter.
Yeah.
Okay, so you're upset. You get this information that's publicly available through the admissions of the Air Force and their congressional hearing. You decide you want to take on this case. How many clients do you represent?
So at the very beginning, a little background is that there's a law that not a lot of people know about called the Federal Tort Claims Act, or the FTCA, which is a congressional law that can hold the federal government accountable in a court of law for negligence, essentially, in concert with whatever the local state laws are. So once we figured out that we believed there was a case under the FTCA, our firm has a national presence in that space, and a lot of folks know that it's what we do. We started getting calls from some lawyers, but we also started putting just general messages out there in our various social media spaces, sort of outlining, hey, here's what we think went wrong. Here's why we think the federal government should be held liable. And here are the next steps for you to take if you think that there may be you or one of your family members may have been involved. So that's how we got started, and it snowballed from there a little bit.
So how soon after the shooting are you able to get the first case on file?
Well, we had our first meeting with one of the families within a week of the shooting, and then I think those families talked to other families, and they started calling us as well. So we had our first claim filed against the federal government, I believe, within a month of the shooting.
And can you tell us a little bit about the claims filing process under the FTCA? What a lot of people might not know is we're actually working on a case together.
Yes. Shooting case.
Yeah. Yes. And you, we called your office because y'all are the leaders in this space, and you educated us on the process to get a claim started. Mm-hmm. So you can't file a claim in open court right away, correct?
Yeah, it's a little bit of a Byzantine structure that the federal government has set up. The king sets the rules, and so one of the things you have to do before you're even allowed to go to a courthouse and file an actual lawsuit is you have to file what's called a Form 95, which is a claim form, and you have to file that claim form, putting the government on notice. Then you got to wait 6 months while they investigate your claim before you're even allowed to file the lawsuit. There are several other hurdles you have to go through, but essentially that's it. And during that 6 months is unfortunately, our experience has been that there's not a lot of investigating going on. It's just a delay process. So once that 6 months is up, we usually file the lawsuit right away.
Now, are you allowed to consolidate your Form 95s? Meaning if you file one plaintiff's and then during that 6 months you sign up an additional 50 cases, or I think there were 52 cases, or 52 plaintiffs here. Do you have to wait 6 months for each individual person?
You do. You do. And this is something that the government will never tell you, and they won't disclose to you if you do it wrong until the motion to dismiss stage, and then you're out of luck. So every individual claim has to be filed, including wrongful death beneficiary claims as well, individually.
Even though you would think common sense would say you could consolidate this because it's the same incident and they're doing the same investigation. So why would it matter?
Well, shockingly, efficiency is not always the number one concern when the federal government waives its immunity. So it's one of those things that we get a lot of questions about. Well, can I just put everyone on the same claim form? Can I just? And my answer is always no. Don't do that. It's jurisdictional. You do it wrong. You do one box wrong. It's a motion to dismiss 12B6. So be very careful to go to the belt and suspenders approach. So we had to do that here.
Okay. So the 6 months pass. You're able to file. Where are you filing? Where's the venue?
Well, the shooting happened in Sutherland Springs, Texas, which is in the Western District of Texas. And so that's where the case was filed. A lot of the negligence actually happened in New Mexico, on a base in New Mexico, but under various choice of law provisions. And for those who don't remember all that restatement, ultimately the shooting is where the venue was placed, and that was Western District, Texas, San Antonio.
Okay. And tell me about the judge you draw.
We had a really great judge. Judge Xavier Rodriguez is a federal judge, Harvard graduate. He was a Republican appointed judge, and there are some that had concerns. Well, is a Republican a good judge for this kind of mass casualty event? And I was really happy at the beginning. I know it's easy to say that now, but I have a lot of witnesses to that. That.
And why would there be hesitation? Why is a judge being a Republican a stigma?
Well, I think it's kind of like, why is being in federal court a stigma for plaintiffs' lawyers? It's a lot of it's myth, and it's not based in reality. I love being in federal court. I think it's great for plaintiffs, and especially if you really care about being a good trial lawyer. And I think the same thing goes with the political ideology of judges. I've had just as many verdicts in bench trials with conservative judges as I have with Democrats or liberal judges, and losses. So the reason why I think there's a stigma is simply because the tort reform era we live in is a conservative political ideology, but I don't find that to be true of most judges. I find that at the end of the day, if you're right on the law and the facts, they're not subject to the tort reform myths that juries actually are subject to.
And that's particularly important for the FTCA because you have no right to a jury trial.
That's right.
Correct. So this is a bench proceeding, especially because there was no third party that you may have looped into this, correct?
Yes, this was and always was a bench trial. We had 2 bench trials because they were bifurcated, liability and damages.
Now, is it mandatory bifurcation?
No, it's discretionary.
And was that just because you had so many witnesses?
Each one was over 2 months long, about 2 months long, and that was after a massive effort in trial management, frankly, by our team to get it down to that amount. The government insisted each one would have to take 6 months.
Wow.
So I think in the end, it was advantageous for everyone to bifurcate it, even though it's not something I would recommend. But on this one, I think it worked. And I think it was necessary to give everyone a breather because this was a highly charged nationally. Media was nationally focusing on it, and there was a lot of pressure. And it was also a just horrific scene and a horrific event that I think it needed that. The families actually needed that break.
So how did it work out? How did all of these families, so there's 52 plaintiffs, and I'm just making an assumption here. You didn't represent them all.
No. So this is a great question. So a lot of the question is, how did I become lead counsel? How did I get to that point? And I did have about a third of the families, and there were several others that also had a large batch, and then several who had 1 or 2 families. And one of the things at the very beginning we had a core team of 3 or 4 firms that really worked well together. And I right away said, listen, I don't want any kind of shared fee or common fund. I'm not going to ask for that. I'm going to tell the judge that. And I did. And I think I earned the trust of everybody. They also knew our background. They knew our firm has been around for 50 years. They also knew that we had a lot of national experience in the FTCA space. And then when I think made that additional step that said there will never be a time where I'm going to ask for extra fee. All I care about is these families and this case because it's too important. And I think that got me the trust of the group, but also the trust of the court to appoint me.
Okay, so the stage is set. You filed your Form 95s. You're in the Western District of Texas. You're the lead counsel. Let's get into the case itself. I think just from observing the media, the very first thing that when you see people reacting to the result of the case online, which as we know now was a $230 million verdict, is how can the government be responsible for the acts of a crazy person?
Yeah, that's a great question. And I'm not, that was a main defense. Main defense is how do you stop a crazy person? It's not our fault.
Can we go into the profile of the shooter?
Absolutely. That's exactly what I was going to talk about.
What was his name?
Devin Kelly.
And
so let me just tell you a little bit about this shooter. It is a very common story. He had a long history of domestic abuse, child abuse while he was in the Air Force. He had a long history of gun ownership and violent use of guns to get his way in his household. That was a part of his domestic abuse pattern, was to use weapons to intimidate, that the Air Force knew about. And then on top of all of that, he had a history of sexual violence that the Air Force knew about well before the shooting. And to put the final, honestly, nail in their coffin, in my view, was that he had repeatedly threatened to commit mass violence generally and mass shootings specifically while he was in the Air Force, and they knew about it.
Wow. So when you say, and they knew about it, was he subject to any sort of court-martial while he was in the Air Force?
He was. He was convicted of domestic abuse, felony, and child abuse. And he was in jail.
So that's a general court-martial. I mean, this is the highest tier.
Right.
He was... So educate the public on what that means. So he is serving in the military under the UCMJ.
That's right.
There's a whole nother set of rules. They call a court-martial, which essentially means that they create a court just for this particular case. A general court-martial is the highest level of court, which is generally reserved for the equivalent of felonies. He gets charged for domestic violence.
He gets charged for both domestic violence and child abuse.
And he's convicted.
Both.
And what's his punishment for that?
He was put into, unfortunately not enough in my view, but he was confined and punished for over a year, which is one of the qualifying conditions to get reported to the FBI. And a court-martial, if you just want to think about it in normal terms, it's a prosecution, like the prosecution does in a criminal case. It's a criminal prosecution of military folks. And, think Few Good Men.
Right.
That's what it was. And so he was convicted of those felonies, put in jail in a brig in military prison, and then released, but never reported to the FBI background check.
So he's in jail for 12 months.
Mm-hmm.
Is he dishonorably discharged after that?
No, they don't dishonorably discharge this guy. They gave him a bad conduct discharge instead of a dishonorable discharge. The reason that matters is that would have been yet another qualifying condition to report him on. Now, they had plenty already, but one of the complaints that I had in the military prosecution was that they went too soft on this guy. He should have been in jail a lot longer than he was, especially when I learned what they knew. When I found out the evidence that they had about this guy, he should have been in much longer. In fact, I think he should have been in long enough to where he wouldn't even been able to commit this shooting.
Yeah, so let's talk about the qualifying conditions for reporting somebody to prohibit them from buying a firearm. Is there any sort of discretion that the government has in exercising this?
Yeah.
I mean, are they saying, is the government's defense saying, look, he was a bad guy, he's a crazy person, we can't be held accountable for him, and on top of that, we had the choice of reporting him, but we weren't required to. And because we weren't required to, you can't hold us accountable.
Yeah. That's exactly right. In fact, you've hit on one of the key defenses in a Federal Tort Claims Act case that the U.S. attorneys always try to bring up. The short answer to your question is no, there is no discretion. There are mandatory internal instructions that we discovered in discovery that left zero discretion for reporting these dangerous folks to the FBI, and also Department of Defense instructions as well, in addition to the federal law, the Gun Control Act, also known as the Brady Bill, that makes it a mandatory prohibitor if you have certain conditions like being a felon.
Okay, so the condition that was triggered here was he was a convicted felon.
That's right. So if you're a convicted felon, or if you have a misdemeanor conviction for domestic violence, he had a felony conviction, but even a misdemeanor conviction, and also if you've been involuntarily committed to a mental hospital, which actually happened here. That was another thing. The Air Force had committed him to a mental hospital because of his threats of violence. And that's also another.
So let's walk through that. Did the threats of violence to the Air Force occur after he gets out of jail?
So no, and yes, partially. He made most of his threats of mass violence and mass shooting threats while he was in the Air Force. We found these in commander memos that they tried to keep us from looking at. We had to get a sanctions hearing. We had to actually hit the U.S. attorneys with sanctions to produce these commander memos. That explicitly said this shooter, Devin Kelly, is threatening command with a mass shooting. And then we got several witness statements that the Air Force had before he was released from the Air Force from other members in the Air Force providing witness statements saying that, oh, yeah, this guy's going to commit a mass shooting. This is the guy. This is the kind of guy that will. So the red flags were everywhere on him.
So they release him from the Air Force.
Mm-hmm.
Upon releasing him, what kind of precautions does the Air Force take?
One of the biggest things that I think upset all of us, and it should have, but also it upset the judge, was that my prior answer, yes, partially, after he was released from jail, the Air Force protected themselves, but not the public. And here's what I mean by that. He tried to come back to 3 different Air Force bases, 3 different times. 2 different Air Force bases. He tried to come back after he was discharged and tried to enter illegally these bases, probably to commit some kind of violence. It worried the military so much that they issued a national security threat notice for every base in the country to shut down this guy from entering and put the highest security risk on him, so that they protected every single base in the country, but didn't tell the public anything. So we were in the middle of trial when they were the government was trying, the U.S. attorneys were trying to assert a defense of, well, this wasn't foreseeable. and you can't put this on us. The judge actually interjected and said, wait a second, I just heard a ton of evidence that you guys were so worried that he would commit a mass shooting on base or violence on base that you shut down the entire country, but not the pub. You didn't warn the public. And he said, quote, you protected yourself, but not the public. And I just said, well, that's been our theme the whole time. That's exactly what our whole theme is. So
how and you already alluded to sanctions.
Mm-hmm.
So I'm assuming that getting proper discovery in this case was not easy.
No, it was shockingly difficult. In a way, I've had a lot of federal cases, and I've gone against the Department of Justice dozens of times, and I've never had the resistance to producing documents and witnesses that I've had in this case.
Now, do you think this was a factor of someone in Washington dictating that, or were you assigned, was it the DOJ San Antonio division who was in charge of this case?
Well, I know it was Washington DOJ.
Okay.
We know that because the Washington DOJ's office is the one that defended the case until it got to the damages trial, and then they left. And they kicked it to the San Antonio office to try the damages trial. But I'll give you a quick story about the hearing, the motions for sanctions hearing. I filed a motion to compel. I didn't ask for sanctions. I didn't even ask for it. I just wanted the documents and the witnesses. But at the hearing, we walked in. This is one of those good lessons of sometimes it's best to say nothing and let the other side
dig their own grave.
Dig their own grave, but also listen, when your opponent's losing, get out of their way. And this hearing started, and Judge Rodriguez rightfully said, U.S. Attorney, have you given Mr. Alsaffar the mandatory disclosures and the witness list? You don't have a discretion. You have to give him those. They're required under Rule 26. U.S. Attorney starts hemming and hawing, the D.C. attorney, and he interrupted and he says, you have 10 minutes. I'm going to take a break because I'm mad. This is a federal judge, and I've never had this happen. He said, you call Washington, D.C. right now, talk to whoever you need to talk to. We're going to reconvene in 10 minutes. And he left. And I hadn't said a word yet. And I said, looked over at my co-counsel, my partner. I said, I'm not saying a word, just not going to say anything. 10 minutes go by. U.S. Attorney comes back. Judge says, do you have authority? Are you going to give the list and documents to Mr. Alsaffar? And he starts hemming and hawing. And he said, is that a yes or is that a no? It's a pretty easy question. And he said, no, not yet. We want to, make sure. And he stopped him. He said, okay, I'm going to issue sanctions. And Mr. Alsaffar, how many attorneys from this are in this courtroom right now? And I said, well, Your Honor, that's the first time I said anything. I said, Your Honor, we have like 20 of them. And he said, okay, give me the billables for every single one.
And these are 20 top partners. Top
lawyers,
yeah.
Best in Texas.
But do you think that even affects someone like the DOJ? Because that lawyer, it's not coming out of his pocket. It's actually coming out of my pocket.
Yeah, it's my pocket. I'm like, you're sanctioning us. Maybe that's why I didn't ask for sanctions. Does it affect them? Obviously they're the best ones to answer. I can tell you that for the rest of the litigation, it was like a parking brake was on discovery. And I can also tell you that DOJ was very upset at getting sanctioned by a federal judge. It did not happen to them. It doesn't happen very much. And this is really important to me. I think Judge Rodriguez was really smart to do this because judges sometimes have to lay down a marker in a case. And often they want us to figure out our own discovery dispute. Yeah. They just want us to deal with those issues. And I agree. I hardly ever file motions. And so what I did in this case is I made sure I papered the heck out of this file. I asked them every way I could in writing, can you please, pretty please, just give me these mandatory lists that you are not allowed to prevent me from getting. But, and I did a month and a half of this, 2 months of this, because I knew I'd have to go to a judge, and I didn't want to. And so the value of doing that was I didn't have to say a word because the judge saw that, man, you guys really tried. Every email I ever did interacted with them, every document I had. And they were. It was very clearly laid out that I was trying to avoid this. And the reason I thought it was smart was after that hearing, all I had to do was say, I guess we need to go back to Judge Rodriguez, and that usually resulted in a production.
For lack of better words, in the plaintiff's world, we call some defense lawyers true believers. They really believe some of the
Yeah.
nonsense they're saying. Do you think that was the case with the DOJ? I would think that, and I'm just making just assumptions here.
Yeah.
If you work for the DOJ, especially in Washington, D.C., you're probably a very highly educated lawyer, probably very qualified. Do you think that there was a little bit of like the sentiment, like, hey, this is not what I signed up for, and they weren't true believers, or were they? I don't know. It just seems so weird
this is
that
a good question.
they are supposed to represent the United States of America, which to me is the people.
Yeah.
But
this is a great question. So I have a lot of thoughts on this, and I'll try to keep it succinct. But I probably, and I don't know if this, I think this is probably true, but I think I'm probably probably the most experience with the Department of Justice from the plaintiff side. I mean, we've had hundreds of cases with them. I think they're wonderful people, and they are smart. To get a DOJ position anywhere is hard. To get it in DC, you've got to be the best of the best. And these are public servants who could make tons of money in the private sector.
Right.
I used to joke with one of the U.S. attorneys in DC, you should join my firm. I think you'd be great. But they're public servants. And they do really love representing the United States of America. But I think there is a cross purposes at times when the people they're going against are victims, U.S. citizens, and oftentimes military families. And I'm representing what I think is the United States when I represent military family. And a lot of these victims in Sutherland Springs were vets. And so I think that's true, is that the reason they're there is because they're like, we're public servants, you guys aren't, and we really do believe in the system. And I think they do. I think DOJ is a wonderful place. But I think that when you have a case like this, it gets confusing. Because I have nothing but good things to say about them as people, because I really do respect them and I enjoy working with them. But I also know I think it's a crisis of identity in a case like this.
So then why would they play such hardball? Why would they try to withhold evidence? I mean, at a certain level, the facts are what they are.
And what was really important to me and the families was this particular case involved national security, in my view. And what I mean by that is it involved making our country better and safer, because the failings that had happened in the military for 30 years were being reported to the military for 30 years. Inspector General of the United States was doing periodic reports on the military for 30 years saying, you're still not reporting, at a 50% failure clip at some time.
Wow.
Tens of thousands of felons to the background check system.
So to clarify.
Yeah.
If I have two people who should be reported, on average, the United States government was only reporting one of them.
Yes.
And was it why were they reporting this person and not the other?
A complete lack of training. When we deposed the people on the ground, the law enforcement officers who are charged with enforcing this rule to report, they didn't even know they had to. And it was a mandatory rule. It was a mandatory law, and they weren't even aware they had to. And so they weren't being trained properly. And at one point, we deposed a colonel. He might have been a general at that point, but he was high-level regional sort of command, meaning he was a commander for like a third of the country, the Air Force. And I finally got him down to that one good question where I said, why? After all that I've showed you and all the reports that were coming, you were being told for 30 years, how did this happen? How is this happening? And he just said, and probably the most honest answer was, it just wasn't a command priority for the Air Force. And that was it. It wasn't a priority. And that obviously became a main part of our, this is why, because you have to explain the why. Right. And the why was, it wasn't a priority for the military. It's that simple.
It wasn't a priority, and it was foreseeable.
Can you think of a more foreseeable risk than someone you've convicted of violence who has threatened to commit a mass shooting has been in a mental hospital? It doesn't get any more foreseeable than that.
Who you protected your own personal assets with.
You were so scared of him, you shut down the entire country to him ever having access to you. And by the way, Tommy, it worked. Once they did that, once they actually did their job and protected themselves, he was never a threat to them anymore. We just asked, you should have done the same thing for us.
So let's get into the Sutherland Springs incident. So he's discharged, he's out of the Air Force, He's not reported so he can buy guns. Where does he buy his guns and when?
He just walks in over and over to a local Academy store, Academy, sporting goods store, Dick's Sporting Goods store. Those are the kinds of places that most people who actually are not allowed to get guns go to. It's not gun shows. It's not private interaction. They like going to stores like FFL stores that are licensed to give guns because they want new and reliable guns. That's one of the things we learned from our experts. And so that's what he did. He just walked in and he sort of was like, in that Jurassic Park when the T-Rex is testing the fence, right? And is just seeing which part of the electric fence is not working so he can break through. That's what this guy was doing. He was just kept going, seeing if he could get a 9mm, maybe get ammo. And then he just kept getting more and more serious purchases.
Was he ever rejected?
Never.
So he builds up his arsenal.
Yep.
And this is November of 2017.
November 5th, 2017.
Why does he decide to target a church?
Not only is it a church, but it's this tiny little house on the prairie church in a 600-700 member community in middle of one stoplight town in Texas. And the reason was that church, and on that day, it was a crime of domestic violence. Now, why? Why do you say it was a crime of domestic violence? The thing he was convicted of by the Air Force. That little church was where his wife and his wife's family went to church. And a few days before the shooting, she told him that she wanted a divorce. And he knew that church was her sanctuary. That church would take care of her. And as you know, victims of domestic violence don't leave their abused partners, no matter how bad it was, and this was bad, unless they know they have a place they can go to that'll take care of them and their child, because she had a child with him. So he knew this church was the only place, and he knew she was serious, and he also knew that her family was in that church. One of her family members was murdered. So that's why he chose that church, and that's why it happened on that day. In other words, Tommy, it was foreseeable. Right. Air Force convicted him of the same thing.
So let's wrap up the liability portion. It's foreseeable. The judge agrees with you after hearing all of the evidence. What does the judge rule on the first part of this bifurcated trial, which is just about liability?
Well, the most important thing I think he found, which was important for all of us, was he found not only that the Air Force was liable, but he found that they were 60% responsible, and the shooter 40%.
Why is that important for anybody who might not be a lawyer listening?
Well, in Texas, under our proportionate responsibility rules, is that a defendant who is found liable is responsible for 100% of the judgment or verdict if they are 50% or more responsible, meaning if the judge or the jury finds them 50.1 or 50 point something percent responsible, then no matter what the percentage is on another party, like here, the shooter, they're 100% responsible for the damages.
So it's 60% put on the United States of America, 40% put on the shooter.
Right.
So you get this ruling. I assume it was weeks or months after the actual liability trial took place.
Yes.
So you get, I'm sure, just an email with an order.
We do.
And what happens after that?
So, well, COVID's happening.
What year? I mean, is this?
Yeah, 2021 through 2022 is when these two trials happened, and so we were the first trial happened right after COVID started when a vaccine started coming in, and then the second trial happened when the Delta virus reemerged and resurged, and so I believe we had the first trial in the country that was a hybrid in-person and Zoom trial with full precautions in place. And then the second trial, after we won the verdict, we thought we were in the clear with COVID, and then the Delta virus started spreading like wildfire.
So you've already established liability. Now
Yep.
It's just a factor of damages. Does the DOJ's tune change? Are they starting to throw out settlement offers? Do they want to get this thing resolved, or have they sunken in? Is it just, are y'all on two separate planets still?
The most surprising thing about the way these families really had to get strung along here was that after, actually before we won the liability trial, I was really trying to engage because we did a really good job of staying quiet and just building the case. And once I got all the depositions of all the highest level folks in the Air Force, it was clear that they did something terribly wrong here. And I thought that would be the best moment, and nothing. Then the trial happened, and it was even worse, I believe, for the government because it went the way it was because of the facts, and nothing. And so I thought, okay, maybe right before the damage, nothing. We never got an offer on the case. And I think my view of this is they thought that I think they were surprised they lost. Then they were surprised they lost with a 60% finding. And then I think they dug in because they said they were worried. And I really don't like saying this, but I think they were worried about a cottage industry of gun mass shooting cases against the government if we held, if we prevailed. And I think that's a terrible reason, but I also understand that that's the reason a lot of people do things. And so I do think there was a strong internal fight and struggle in the DOJ about doing the right thing here. And I know a lot of people in the DOJ who I think wanted to do the right thing, and ultimately they did, but we had to get a trial verdict to do it.
Well, so you get the liability verdict. Mm-hmm. There's no offer, so now you're forced to go try the damages trial.
Right.
Tell me about that. How long was it? You have 52 plaintiffs. I'm sure that was extremely emotional. How long did that take? How did you effectively get across the? It sounds so crass to say, but how do you make each individual's pain and suffering not just kind of mush together with, just get lost in the crowd?
I think that was the number one question, honestly. That was the number one thing that worried me the most was, how do I do two things? How do I get the court to understand what these families went through? This was a really small space, this church, tiny church. And there was a absolute guerrilla warfare in that little tiny space where over 500 shots were fired in a matter of minutes. The scene was the goriest scene I've obviously seen, but it was the worst crime scene that the Texas Rangers had ever seen. The Texas Rangers, by the way, who handle drug cartel cases. The Texas Rangers were suffering from PTSD just seeing it, much less going through it.
It was a slaughter.
It was a slaughter in a confined, tiny space, and so one of the hardest things that I had to figure out in this case was I didn't want to do something fancy. I didn't want to do recreations. I didn't want to do all those things that you think about maybe in a trucking case or in a product liability case or a device litigation case. I didn't want to do that. I wanted to strip it down, and I wanted to find a different way to present that scene first. And so what I did was I spent a lot of time with the Texas Ranger, who was the head investigator. He was my first damage witness, was the Texas Ranger. And he walks in with his cowboy hat and his boots, and he looks like Texas Ranger, right? Toughest guy you'll ever meet. And when I spent time with him, he still cried when he talked about the scene. He could not stop himself from crying 5 years later. So I knew that would happen. But I think one of the most effective things I did thinking about this was I asked him to measure the courtroom, and I asked him to measure the church, the sanctuary, because I had this feeling that they were the same size or close to it. And he did that, and he told me before he got on the stand, Jamal, they're almost exactly the same size. Because I had this sort of epiphany, being in the courtroom a lot, I said, wait a second, the courtroom looks like a small sanctuary in a church. What's the first thing you do? You walk through the front door of a courtroom, and there's pews to the left and to the right. And then you walk in, and then what's in front of you, dead center, elevated? It's the judge, but it's also, that's what a church looks like. It's where the pastor gives his sermon or her sermon. And it kind of hit me, oh my gosh, that's what we're going to do. So he described that. He did, not me. I just said, and he did it in a very effective way. And then we had audio, 911 calls, audio piped in during his testimony. And from that moment on, the rest of the damages trial, every time that door in the courtroom opened, when someone came in or out or what, the entire courtroom, the judge, the staff sat up and looked at the door to see who was coming in. It was sort of an alert response. And I knew then, I said, okay, they're in the space and they're going to be in this space. And then that's the second challenge. The second challenge, how do I get these stories told?
And tell me about, we don't need to go into the detail of the victim's stories, but tell me about the categories of damages.
So we had every single category that you can have in a case, because we had 26 people killed, 22 people severely injured of all kinds, paralysis, loss of limbs, loss of, nerve use, and then relatively minor, but all emotional, just, all over the spectrum. So I really made a commitment. I told the judge during the pretrial hearing, said, Mr. Alsaffar, I'm going to give you as much time as you need because this is too important, but is this going to take 6 months? Because you've got over 100 witnesses. And I said, no, I can do it in a month and a half. And he laughed. He's like, no, you can't. And of course, the DOJ was like, it's going to take 6 months. And I said, here's what we're going to do. I'm going to figure this out. I'm going to break this down. I'm not going to put any person on the stand more than 45 minutes. If you hold the DOJ to the same standard, they get the same time as I do, nothing more, I'll get this done in a month and a half. But that's the one rule we have to have.
What was the DOJ's approach to taking on these witnesses?
It was sort of, I would say, what you'd kind of expect. I felt like and this happens a lot, I think, in damages cases that are severe. I think the defendants, and this happened here, they try to nitpick on little things that don't really matter. They question sometimes the credibility of people's complaints. And that happened here, and it was a big mistake because you cannot overestimate or over-embellish what happened here. There's just literally, we don't have the vocabulary to describe how severe and terrible this was. And so I think that typical tactic that you see, which was employed, actually backfired. The harder part, honestly, was how do I present all of these family members without making it desensitized to the trier of fact. So we were able to do that, but it took a lot of work.
So you get an award of $230 million. Mm-hmm. What happens after that?
Well, they finally started talking resolution. So the government filed an appeal to the Fifth Circuit, and ultimately we settled the case for about $145 million, which is about 64% of the verdicts. So a little more than what the judge had assigned their responsibility as. And it was the highest settlement that the federal government has ever entered into. Yet still, I felt it, was a little bit disappointed, but in the end, everyone was really happy. The families were happy because, we had to be realistic that we were going to the Fifth Circuit, and it's not the friendliest venue for individuals that are injured.
Money aside, I'm dabbling in some class action work, mm-hmm. and I'm learning this as I go. In order to get some class actions settled, you need to propose recommended changes. The court not only needs to hear the monetary compensation that the victims are going to get, but they need to have, some recommended changes that the defendant's going to take, so you're not back in that courtroom a year from now.
Yeah.
Did the government take any sort of responsibility? Are they making any changes as a result of your case?
Yes. I will say this is in my view, the most important thing. And this was the most important thing to the families. We could not get this settled unless the families knew what I'm about to say. And that was two things. The first thing was that as a result of the lawsuit, the federal government revamped the entire background check reporting system. And so, and when I say revamped, they put hundreds of thousands of felons back on the rolls so they can't get guns. But they also changed entirely the process of reporting, how they have safety nets and checks in place to ensure that when someone's convicted or has a qualifying condition, they get reported almost exactly in the same manner our experts recommended. And since the lawsuit was filed, and I'm not exaggerating this, millions of criminal records have been put into the national databases. And their percentage of success has gone through the roof in terms of making sure that they don't slip through the cracks. So for the families, we can literally tell them, because you stood up and filed this suit, made the entire country safer as a result.
Wow, that's incredible.
Yeah, it doesn't happen a lot.
Yeah.
Yeah.
I mean, I know it's a little bit esoteric, but that is that's what I believe being a plaintiff's lawyer is all about.
You know, listen, the reason when I was 16 and I decided I wanted to be a trial lawyer because I read Atticus To Kill a Mockingbird and I wanted to be Atticus Finch. And I remind people, he became a hero and he lost. It wasn't about winning or losing. It was about taking a stand for what was right. In all of my individual cases where we help families, I feel great, but it's rare that we get an opportunity to make the entire country safer and better. And this happened because of these families trusting us to try this case. And it's only spurred me on because I look at it, and as hard as this was, at the end of the day, that's why we do what we do. And to be able to say, no, what we can actually affect change when our politicians clearly won't, especially in this area of gun violence. And so that's why we've gone on, and our firm has tried to go on and be involved in more of these, because we can see that you can make that change happen.
Well, good work on the Sutherland shooting case, and
Thank you.
I hope you never have to work on a case of that size again.
Well, I have a saying. I've been telling people this, that I'd like to make mass shooting cases history, not headlines. And ultimately, that's the goal. Let's get rid of this, because it's a problem we can fix.
Yeah. All right. Well, Jamal, thanks for being on the show.
Thank you.
I appreciate your time.
Yeah, it was
All
fun.
right.
Thank you.